Good evening and a very warm welcome to this lecture meeting on a very contemporary topic on the recent Supreme Court judgment in the context of Safari Retreats Private Limited. Today, we have the pleasure of hearing views of none other than Senior Advocate V. Sridharan sir, one of the finest legal brains in our country today. Sridharan sir, in year 2024, BCAS completes 75 years of its existence. And what started as a small group of professionals meeting every Wednesday has today snowballed into thousands of members across 350 plus cities and towns in India. And till today, the culture of holding lecture meetings on Wednesday continues as we have today. Friends, from a macro perspective, the GST law seems to be in its third phase of evaluation, for lack of a better analogy. I suppose every major law goes through such phases. In the first phase, it started when the law was introduced in 2017, and maybe from 2017 till 20, prior to COVID, the basic tax collection filing mechanism went through the maturity curve. In the second phase, from 2020 to 2024, was when the enforcement and assessment mechanism started to take a true shape. Not that any of these two have reached an ideal state, but now nonetheless, we seem to be in the third phase of judicial review and constitutional challenges which are coming to fruition. We have started witnessing more and more matters reaching and being settled by the apex court, and many important matters are scheduled to be concluded in the coming months. In this context, we have the Safari Retreats judgment, a judgment arising from challenge by the revenue on an order by the Odisha High Court. The matter deals with eligibility of input tax credit for immovable property, particularly properties like shopping malls meant for leasing and renting. As we are aware, under Section 17(5)(d) of CGST Act, developers were not allowed to claim ITC on the GST paid for goods and services used in constructing immovable property meant for own purpose, even if the same were used in furtherance of business, resulting into additional financial burden. The much anticipated judgment from Hon'ble Supreme Court has brought relief not only to real estate developers, but potentially also to other industry players involved, like construction of port, jetties, warehouses, and other infra projects. Though the Supreme Court has rejected the challenge to the constitutional validity of Section 17(5) C and D, the acceptance of the submissions of the petitioner, who are the meaning of plant and machinery, is a positive outcome. The ruling comes as a ray of hope, indicating that buildings and malls can be treated as plant and emphasize on a case-to-case based analysis on the functionality test to determine the ITC eligibility. There still remain open issues around applicability to the principles under the judgment to various other business types and nuances. And to discuss the judgment as well as the nuances, we may proceed further with today's agenda. My compliments to the Indirect Tax Committee for scheduling this lecture so quickly so that our community can benefit and take maximum advantage of. Once again, a warm welcome to all of you all, and very happy to see an audience of 700 plus registrations today. Over to you, Dushyant Bhai. Thank you so much.
Good evening all, and thank you, President Sir, for the wonderful opportunity to introduce Senior Advocate V. Sridharan Sir before all of you present. V. Sridharan Sir is a Bachelor of Law at Delhi University, a Chartered Accountant and a Cost Accountant. V. Sridharan Sir is the co-founder of Lakshmi Kumaran and Sridharan, the firm which is well known to all of us. Sir has been designated a Senior Advocate by the High Court of Bombay. He has successfully litigated on tax matters for nearly 2 decades at various judicial and quasi-judicial forms like Customs Tribunal, High Courts, and Supreme Court. Many of the cases argued by him are landmark legal cases. His vast experience, coupled with his knowledge in accountancy, economics, and tax laws, is immensely appreciated by the bar and the bank. He is considered as an authority on customs valuation. His areas of practice include indirect taxes such as customs, excise and service tax, sales tax, and value-added tax, international trade laws, intellectual property laws, and corporate laws. He regularly delivers lecture on indirect tax laws at various institutions, and of course, BCS is one of them. With this, I, on behalf of BCS and all of present here virtually in this lecture meeting, welcome sir and request him to guide all of us on the given subject. Thank you, and over to you, Sridharan sir.
Good evening to all of you. The introduction by the president makes me a little nervous because he has summarized the topic better than what I could have done over a period of 1 hour. And my dear friend Sunil is also on the line, no? Suppose I had asked some points to him, he will be able to. Okay. Or I can ask Mahendra. Okay.
Sunil bhai,
yes, I'm very much there, sir.
Yeah, no problem. No problem.
I'm there. I muted myself.
No difficulty. No. The session is up to about 7 o'clock or so.
Sir, we have up to 7:30, and then maybe a few questions.
We'll because we are discussing one judgment, so we'll give more time for questions then. Okay. And I'm told a series of articles and webinars have been held on this judgment. And I'm told Lakshmi Kumaran sir himself gave a webinar about a week ago on that. I was held up in Orissa High Court. Finally, on Sunday, one message came from client, I want to meet you urgently in Madras tomorrow on Monday, he said, last Monday. I said, I'm in Orissa High Court. Then he rang up saying that, sir, you're in Orissa High Court after remand from the Supreme Court. That matter in Orissa High Court is a customs, but nothing to do with it. The client was so overwhelmed with his ideas of this issue. He thought I rushed to Orissa High Court for taking up the remand after remand. Nothing on this kind. Our president points out that this judgment is a welcome relief for developers and other infrastructure companies, etc. I'm not too sure about how beneficial it is. Okay. The one part of the judgment which is clear and unambiguous, and which I have always had a view, is that the section 17.5c and 17.5d will not be struck down as violative of Article 14. I repeat, the Orissa High Court judgment, however fair and equitable it was, to say when the Parliament of the state legislature enacted section 17.5c and 17.5d, there was a discrimination inviting the wrath of Article 14 of the Constitution, and therefore the section has to be struck down or read down. I was always doubtful. The Supreme Court judgment is ex-face clear on this. The sections as enacted are perfectly valid and they do not violate Article 14. So this part of the judgment is clear. We'll since, and Sunil Bhai told me that the questions we are all concerned with does not relate to this part of the judgment at all. But I must explain this part of the judgment with some detail because it sets out the background for that. The other part of the judgment, upholding section 16.4, the time at which you can take credit, etc. It's a very brief discussion. That was not the focus of the case. Some petitions got simply tagged on. And that section has also been upheld. So various high courts, the Madras High Court and this High Court upholding, striking it down, etc., become meaningless. And the time limit specified in 16.4 has been held to be perfectly valid. And it's very difficult to expect a 3-judge bench to overrule either of them. I don't think that will happen. That will be realistically possible. So these two parts of the judgment are complete and not in assessee's favor. As I mentioned to you all, I'd like to spend some more time on the validity of these sections vis-a-vis Article 40 of the Constitution. It is not a theoretical exercise. It's not an academic exercise. It's not an exercise by a so-called high-flying lawyer who talks in the air and not going to the depth of the matter. There's a purpose behind this. Some months ago, one of my juniors called up from Calcutta saying that this Orissa High Court matter in a sales tax matter, and that's on input tax credit. We have challenged the constitutionality of the section. I said, in input tax credit, is the largest with the government. Whatever government gives, you have to take. You can very rarely get the section struck down in a VAT matter, input tax credit matter. The issue in that case was the assessee is manufacturing and selling goods on which pays output tax as a captive power plant, and he uses fuel for the power plant, which in turn is used for making the finished goods which are sold. So the junior was influenced by central excise concept. So the electricity is for captive consumption. It's my intermediate product. I don't sell the electricity at all. Entire output of mine is liable to VAT. How can they deny credit on fuel? And therefore it's violated of Article 14, sir. I told him, and I request all of you to listen to this sentence a little carefully. I told him, please wait. The government will come up with a fanciful explanation. I told him the government will give an extreme example and justify this section. What is the section? Which denies input tax credit for fuel used in power generation, even if it is a captive power plant. Okay. And even if it's a captive power plant and the final product is taxable. Captive power plant for a final product is exempt from sales tax or VAT is not the issue. It was liable to tax. I told him the government would give an example that with an independent power plant generating power, say like electricity board, on that sales tax is not being paid, VAT is not being paid with sale of electricity by the electricity board. They will not be eligible to have input tax credit. In order to ensure a level playing field between an independent power plant which supplies power to a taxable entity and a captive power plant which is using it in-house for sale of finished goods, we will deny input tax credit to a captive power plant. In other words, I'm not saying in a wrong sense, in some sort of a cursed approach, they said IPP cannot be given input tax credit. I will ensure level playing field by denying to fuel used in captive power plants. Captive power plant in turn using for taxable goods. That's how level playing field can be achieved. The correct course should be they should have given some 0 rating for independent power plants. Instead, they say they are denied the credit. I will deny credit for fuel used for power generation, even by captive power plant. When I told him, how can it be, sir? You are totally negative, sir. You have become old, you have become pro-revenue. All this Rahul told me. Then 2 weeks later, he said, sir, revenue has filed a counter affidavit saying exactly this reason as a justification for introducing a section. Because when you're challenging the validity of a section, We are not concerned with the meaning of the words because meaning of the words are clear. You are not eligible for input tax credit and fuel used for power generation, whether captive power plant or not. There is no interpretation possible. The only excuse for the assessing is the section itself should be struck down as being discriminatory. And the answer given by the government is matter still pending, formally pending, where the revenue is to have a level playing field for fuel used for power generation in captive power plant and fuel used for independent power plants. In my guess, in my hunch, it's purely a guess. It's a hunch. It may be totally wrong. There's no basis for what I'm saying. Some such logic is what is weighing with the government in enacting section 17(5)(c) and D. I repeat, I have no basis for what I'm saying. This is only my hunch. They say under item 5 of schedule 2, pre-OC construction is liable to tax. Post-OC is exempt from tax. Both by virtue of schedule 5B as also by schedule 3. So sale of a completed building, there is no output tax. Therefore, if a chartered accountant for running his office buys a flat which is OC has already been received, the developer who sells the flat to CA is not going to charge GST. And the chartered accountant, who is the consumer of the service, will not be able to take credit. The developer would have had input services and goods, etc. But these are used in post-OC sale, therefore he will reverse the pro rata credit. Take another CA who was contracted with the developer at the pre-OC stage. The developer will charge GST. If 17(5)(c) and D are not there, CA could have taken the credit of that and chain could have been maintained. According to the government, since I am denying credit, chain will be snapped when the post-OC sale takes place. I'm not saying in the wrong sense. I'm not saying in a cursed manner. In a negative sense, negative approach, government says we should deny credit even for pre-OC sales. That's the logic. That's why I gave the example of the power plants. And that's the logic adduced by the learned additional solicitor general before the Supreme Court for sustaining the section 17(5)(c) and D. Supreme Court, of course, has not gone into in detail, but upheld the validity and accept the ASG submission. But you can clearly see the line of reasoning of the government and the unstated thought process by the Supreme Court in upholding C and D. If they miss this point, then Orissa High Court judgment will become perfect. Therefore, the only excuse they can give for 17(5)(c) and D is we want to ensure level playing field between persons who buy a post-OC flat and buy a pre-OC flat. And level playing field, not in the sense of giving credit, which is the essence of GST, but by denying credit to both. That's the logic behind it. I don't know, you all must have come up across this position, and I have mentioned this example a number of times. In UK, insurance supply is exempt from GST or VAT. If the insurance company buys stationery from the market, the stationery supplier would charge VAT or GST. Insurance company will not be able to take credit of that. And that becomes a cost. And therefore, if the insurance company sets up its own printing press, stationery press, and itself print the stationery, etc., then it will be self-supply. No output tax will be payable on supply of stationery from one division of the insurance company to another division of the insurance company. And such integrated activities have a competitive advantage. The European countries are obsessed with fiscal neutrality to the point of madness. They say everybody should have the same level playing field. You must compete in the market on business reasons. You should not have tax advantage. Your success should not depend upon whether you advise to Sunil Gabawala, who will give best possible advice. And such clients will be benefited rather than clients who consult Sridharan who will give outdated advices. To have a level playing field. Therefore, they have a specific situation. Entities which are exempt, carrying out exempt supply, if they take up an activity for self-supply basis, which is ordinarily not treated as part of their main activity, then they will be deemed self-supply tax. There's a position in UK VAT. Okay. Our 17.5 C and D are not identical to that, but this is the inspiration behind the section. I'm spending time on this because once you understand the logic behind this, then we can understand the other implications the judgment is dealt with. It's also a possibility that 17.5 C and D are influenced by similar provisions in service tax and VAT credit rules, where input service credit was not allowed, the 2L for similar activities. So far I have told you unambiguous portion of the judgment of Supreme Court, and which in my humble opinion are otherwise correct also. 16.4 upheld, 17.5 C and D upheld. And the logic behind 17.5 C and D is not available in any GST Council minutes, nothing, nowhere it is available. But the grain behind the thought process is easily decipherable for what we have seen, what I told you just now, and also clear from the judgment of the court. Sunil Bhai is okay so far?
Yes, sir. It's going well, sir. Please carry.
Okay. All right. Can I go to the next topic? Unconnected topic.
Yes, sir.
Okay. One of the principal bases of the judgment of the Supreme Court is 17.5D uses the word plant or machinery. 17.5C doesn't use the word plant or machinery, it uses the word plant and machinery. You all very familiar with that. I will repeat it. I repeat, Supreme Court says 17.5D uses the word plant or machinery. 17.5C uses the word plant and machinery. Explanation defines plant and machinery. The argument of the Solicitor General, there's a small clerical error in drafting using the word or in 17.5D is incorrect. Okay. And it should be read as and. Court rejected it, saying plant or machinery will be read as plant or machinery. Will not be read as plant or machinery. Why did the Supreme Court say so? They say once it is plant or machinery, the explanation defining what is plant and machinery is not relevant. That's the first finding. Second reason they say, if you are concerned with the word plant and machinery, explanation says apparatus, equipment and machinery. Nothing outside that will be covered. So that explanation is not applicable. Two, when the phrase used is plant and machinery, the word machinery will throw light on the meaning of the word plant. When the words used in the section are plant or machinery, the meaning of the term plant will be uninfluenced by the term machinery. And therefore, the Supreme Court took pains to say that 17.5D applies to plant or machinery. Supreme Court says it will not apply to plant and machinery, which is the question in C. My colleague Nivedita says in SGST Act of what are the states?
Rajasthan, Jammu and Kashmir and Puducherry.
Rajasthan, Jammu and Kashmir, Puducherry. 17.5D of the SGST Act uses the word plant and machinery. The first question is, therefore, we all thought is one nation, one tax, etc. Okay. What's the effect of this? Are you to ask the client whether you are in Rajasthan, whether in Pondicherry or this? And we had asked whether the supplier is to be seen or recipient is to be seen. It's all absolute confusion. Okay. The Gazette copy of the state acts in these three states say so. I'm also not sure whether there is any errata in the Gazette for CGST Act in English version, correcting the word or as and. I tried to locate, I was not able to locate. It's possible also, because there is no link between the errata and the main Gazette. I'm not sure about it. But Nivedita, there's something more drastic. About
So the Hindi version, the Hindi Gazette version of the CGST Act uses the word plant and machinery in Hindi. I'll just display that for you. 1 minute.
read it.
So this is section 17(5)(d) in Hindi. घ किसी कराधेय व्यक्ति द्वारा अपने स्वयं के वास्ते संयंत्र और मशीनरी से भिन्न किसी स्थावर संपत्ति के सन्निर्माण के लिए प्राप्त किया गया माल या यस सो इफ यू लुक एट द ब्रैकेट इट सेज संयंत्र और मशीनरी से भिन्न
सी में भी ऐसा ही है.
यस सर इफ यू लुक एट गो संयंत्र और मशीनरी से भिन्न.
So this is not a case where if there's a conflict, between Hindi and English, which will prevail, etc. Okay. To the extent possible, they should all be read together. Okay. And this has not been noted in the Supreme Court. Whether the government will do so in the review petition, what will be the effect of it, and because of this, what will happen? Some other matter, the court will say this aspect is not brought to our notice, and therefore will read or as and. I do not know. I do not know. Okay. So, Sunil bhai, you have seen this part?
No, I am enlightened today, sir.
Okay. I told Nivedita, इधर पे और ही लिखा है, what are you saying करके. Mr. Arvindadar used to tell a joke. There was a Justice Atravel Pandian was from Madras. His Hindi is even more negligible compared to mine. So there were two judges who finished a meeting, came out to the hotel room. So the judge told his driver, "Aa jao." Okay. So Hindi speaking driver called this thing. So Justice Pandian telephoned his driver and said, "Jao." Okay. So the driver left, he was waiting. Aa jao. Okay. Anyway, that's okay. So what will be the impact of this? We do not know. Whether one is Rajasthan, Puducherry in Jammu and Kashmir is one problem. Other is the Hindi version of it. Okay. Yeah? That's a different controversy. Okay. Now let us ignore that. Let us stick to what the Supreme Court has said. Perhaps the entire attention focus was shifted to plant and machinery point than anything else. I must point out that I have given hundreds of opinions saying the meaning of 17(5)(c) should be derived from 17(5)(d) and vice versa. In other words, they will be literally read as pair of words. For example, when I say null and void, if you ask for what's the difference between null and void, it's impossible to decide, to say. If you say pipe and tube, what's the difference between pipe and tube? These are pair of words. So 17(c) and (d), literally one will throw light on the other. And therefore you must read C in the light of D and D in the light of C. The judgment of the Supreme Court clearly rejects that point and says there is no connection between these two. They are treated as independent clauses. I'm mentioning this because even if the plant or machinery is read as plant or machinery, still 17.5C and 17.5D will be read as separate clauses. The reason why I gave this opinion in the past was also something to do with the meaning of the word on his own account. 17.5C bars input credit when you receive input service in the form of work contract service. As you know, work contract service, we'll have time to deal with that. Work contract service will mean when the supply involved both goods and material. Therefore, if a recipient tells his supplier, you supply goods only, tells another supplier to supply labor only, or the same supplier, goods is one contract, service another contract. Therefore, he goes out of the clutches of 17.5C. He buys the goods, he receives services and reissues them to a contractor. Buys goods from A, receives services from B, issues them to C or to A and B. And it then says, I have not received work contract service, therefore 17.5C will not be attracted. 17.5D is enacted to prevent circumvention of 17.5C. That is the view I had given. The Supreme Court judgment clearly, of course, with the adverting to this aspect of the matter, clearly rejects this point and says 17.5C and D are independent. Don't try to read or misread one in the light of another. So that's part of the judgment is also very clear and useful to us. The next part of the judgment, which is important and which is on his own account. In 17.5D, Supreme Court's specific 17.5D on his own account is used, apart from plant and machinery, plant or machinery. The Supreme Court specifically says these two exceptions are separate exceptions. These two exemptions from exceptions are also separate in the sense no credit. In the no credit formula, there are two independent statements. If you fall in either of them, you will be eligible for the input tax credit. One is on his own account and plant or machinery. On this word, on his own account, the description is not elaborate except in para 32. And I am told by everybody, whole demand and dispute and discussions are on para 32. As Nivedita shows in the slide, is it possible for an assessee to say 17.5D is not applicable to me because it is not on my own account? I need not look at plant or machinery. Even mine is a building which is not the nature of plant, but is not on own account. Will I be outside the clutches of 17.5D? And the reason people say is 32 there is only brief discussion and that in one sentence only. Subsequent discussions again go back to plant, etc. And therefore, it is not enough for you to say it is not our own account. You must also show plant. Or meaning of the word on his own account is not to be judged from what is mentioned in 32. There is an overlap between the meaning of the word plant stroke building. Okay. And therefore, even if it is on own account, if it is the nature of a building, not the nature of a plant, okay, Let us assume for a minute, Supreme Court has concluded that a hotel or a cinema theater can never be building, can never be a plant. Okay. But if cinema theater is constructed with the whole intention of letting it out on lease, Supreme Court elsewhere says whatever is given on intended to be given on lease, etc., is not in his own account. So theater intended to be let out will be, though not a plant being in the nature of building, but intended to be let out is not own account. Is that the interpretation? That's the doubt, no, Sunil Bhai?
Yes, I think the doubt is rightly expressed.
Okay. What is your view on what's the correct answer about the Supreme Court judgment?
Sir, as we discussed, I don't think the Supreme Court has really given a detailed finding on this. So I'm as confused as most of the other participants here. But yeah, it's a bit tricky because there's just one line, as you rightly said, in para 32 on this.
On a plain reading of the section, is very clear that there are two escape routes for Nasasi. If it is not on his own account, then escape route is there. If it is not, if it is plant or machinery, then also escape route is there. I don't think anybody will trouble us on that.
Yes.
In other words, even without the judgment, we can easily say there are two gateways, exit gateways out of the class of 1750 to Nasasi on his own account, and this second point, plant or machinery. There the judgment is saying so, and I think it is correct, and there's no problem in that.
Yes.
In other words, even subsequent judgments want to revisit some portion of the judgment, this part will not be a problem. But the real problem is on the meaning of the word on his own account. Does it mean that if the building is intended for lease or license or renting, etc., automatically and always it is on his own account? I repeat, what is the meaning of the own account? It's a different question. That if it is on his own account, if it is not on his own account, you are outside the class 17.5D. There's no problem in that. But what is the meaning of this on his own account? The Supreme Court seems to have laid down in Safari Traders that moment it is intended for lease, etc., then it is not on his own account. Supreme Court seems to clearly said that. Whether it is right or wrong, I need not debate. I need not bother about my personal views on this. But clearly Supreme Court says, if it is renting, etc., it amounts to not on his own account. Therefore, my submission in this regard are this. One, the Supreme Court has clearly held the escape route to the assessee are two separate escape routes in 17.5D. One is on own account, second is on plant or machinery. If you satisfy any one of them, you are outside the clutches of 17.5D and will be eligible for the benefit of input tax credit. Judgment says so clearly, and that will be easily accepted by any court. There's no problem in that. The meaning of the word on his own account, Supreme Court is clearly held that once it is meant for renting, leasing, etc., okay, it is not on his own account. There also, court judgment is unambiguous. Whether that conclusion is right or wrong, we need not bother. Supreme Court is final, unless the larger bench revisits this point. To reiterate, moment the building is intended for lease, license, renting, etc., it is not on his own account. That's also clear. The next question is on plant and machinery. Sunil Bhai says the functional test is little confusing. If a gold medalist in CA can be confused, then what can people like me do? But right now, let us ignore this point of the functionality test. What is a plant? What is a machinery for a few minutes? There seems to be a clear suggestion in the judgment of the Supreme Court. Whatever else may be plant or not, two people are being cursed to be not a plant. उनको ऊपर श्राप है क्या? हिंदी is correct word. One is theater, second is hotel. Matter may be rediscussed for a mall, warehouse, etc. Functionality test. Supreme Court says specifically in the context of income tax for these two people, we are held. They are not plant. The building, it is a building, not a plant. So that part of the matter is foreclosed and is not available for argument for a tribunal, high court, etc. The question I am posing to all of you is, if I said few minutes ago, there are two different distinct escape routes, one plant or machinery, another on his own account. Whether judgment cursing, I'm using the word in a lighter sense, cursing this theater and this is focused on the word plant only, or inherently they are held that hotel and theaters can never get input tax credit. They are hit by 17(5)(d). Have they said so? To my mind, no. My answer is assessee's favor. Supreme Court said hotel and theater not a plant because of binding precedent in Anand Theatres. Those judgments in Anand Theatres were not at all concerned with the word on his own account. They were concerned only with the meaning of the word plant. Since in the fact situation of a hotel and a theater, Supreme income tax is held, there is not a plant, this judgment simply follows them. Hotel and theater have been held to be trapped with 17(5)(d) only because they are not a plant. The other point on his own account, according to me, is not concluded against the hotel or theaters, and that is available for contention and claim by the assessee. I have a difference of opinion between Nivedita and me on this point. This is a judgment of House of Lords in Barclays. Huh? Hotel? Barclays Hotel.
Yes.
Barclays. Citation milega?
Just 1 minute.
Okay. There the question was whether that hotel which is redesigned and putting chandeliers, etc., will be eligible for plant. Like we have initial depreciation, UK Act also had for first year allowance on capital items. There is an existing hotel which was meant for businessmen. It was converted into tourists, no?
Yes.
And incurred expenditure on chandeliers, etc., etc. The judgment was concerned with the expenditure on chandelier, etc., whether that is a plant. My colleague Nupur points out that assessee himself came up before the lower court, the construction relating to ducting, etc. Electric wiring, etc. He did not claim. He claimed only for the chandeliers and furniture, etc. The House of Lords held it to be a plant. Perhaps the judgment was considered in Anand Theatre. I'm not too sure about it. You may say, sir, that judgment in UK holding this to be a plant is inapplicable because Anand Theatre and Safari Retreat specifically says hotel building is not a plant. I agree. But that judgment has one important line. And that's where my difference between me and Nivedita and Nupur is. The judgment says normally the building from which you operate itself is not plant. Normally, the building from which you operate is not a plant. Okay. So a lawyer or chartered accountant, even if he meets the client in his own office, it is meant for his own employees and accountants and lawyers to work. It's a setting from which business is carried on by him, profession is carried on by him. Incidentally, customers come and visit. Similarly, a bank's branch, customers come and visit. But still, predominantly, it's a setting from which the businessman operates. In the UK case of plant, the House of Lords took the view, the chandeliers and the furniture, etc., are made available by the hotel for use by the guest. And the hotel earns money out of that. In other words, while holding hotel to be a plant, in these sort of items in a hotel was a plant, the reasoning given by the House of Lords is that is made available to the client for enjoyment and you earn revenue out of it. So, this part of the judgment of the House of Lords brings out the clear distinction when it will be a setting, when it will not be a setting. When it is made available to the customer enjoyment and you charge for that. Okay. That was a test for plant in that case. That test may fail in India because of Anand theatres. But that part of the judgment House of Lords, that it will be on his own account. The word is not used on own account in the judgment of House of Lords. Section did not use that. In other words, in my humble opinion, I'm not sure about theatres. In my humble opinion, hotel is intended for the shell of the hotel. I'm not talking about the chandeliers and the bedding and linen, etc. in the hotel, which is made available to the guest. The shell of the hotel, maybe there are few rooms in which the accounts department works, etc., legal department works, etc. Ignore that for a minute. Even the shell is made available to the customer for use. It may not be a plant, but in my opinion, it satisfies the definition of on his own account. And therefore, will be outside the clutches 17(5)(d). Nivedita agrees with me on this, but she says your reference to House of Lords is irrelevant and incorrect. So that may be additional reason I give, you can ignore that. So the purpose of the discussion is to only say that matter for a hotel is not shut out. Under 17(5)(d), still he will not be eligible as plant, but on his own account, he will not violate that condition. It is made available to the customer. And that test can be equally applied. In a mall, you may say that is never made available to the customer, but it may not be a plant. Okay. So this is the purpose of this 5 minutes, 10 minutes repeated repetition is because somebody says para 32 is independent to be read like this, etc. I have no doubt the two independent conditions. Okay. On account is expressly held by Supreme Court not to cover rentals. Okay. And hotel is intended for renting out and you earn revenue out of that. Therefore, hotel will be eligible for credit at 17(5)(d) because it is not on his own account. That's all.
Yes.
Sunil Bhai, anything else on this? You want me to take up the next topic of the
Sure,
difference between 17(5)(c) and D and works contract? I'll separate deal with the functional test.
Sure, sir.
Ijazat hai?
Yes, sir. Please carry on.
So 17(5)(c) says no input tax credit on works contract service. In fact, one of my chartered accountant friends, very enthusiastic, of course, is much more sharper than me. He gave number of reasons, the difference between 17(5)(c) and D. Okay. 17(5)(c) refers to section.
I'll display the section.
Works contract service when supplied for construction immovable property. And it is referring to from the supplier's point of view, not the recipient's point of view. D, goods and services are both received by a taxable person for construction immovable property. Okay. So there is a, my friend was explaining, Mr. Kothari was explaining, sir, there is a big difference. In C says works contract service from the point of the procurement when supplied for construction immovable property. D, goods and services are both received by taxable for construction immovable property, for construction immovable property by the supplier of goods and service or supplier construction by a taxable person. We don't know. And C doesn't refer to taxable person, D refers to taxable person. Supreme Court also has a number of differences between C and D. Okay. We'll keep aside for a minute. Construction immovable property is a common term, but by a taxable person qualifies receipt of goods or for construction in D is unclear. But let us go to C for a minute. Works contract service when supplied for construction immovable property. Incidentally, unconnected with this matter, there is a dispute, I am told. When you pay GST on premium for land or rent of land, will that be eligible for credit? Will it be by C and D? That is not dealt with the judgment. There are various views in this. We'll ask Sunil Bhai for his view. But prima facie, according to me, lease paid or lease premium, GST or lease premium on land or rentals of land will not be trapped, will not be denied the benefit of 17C and D because they are not for construction immovable property. Works contract service when supplied for construction immovable property. According to me, it will not be. That we'll deal with in a minute, little later. So C refers to works contract service from the input side, from the supplier. We all know the difference between a normal sale of goods and works contract. Normal sale, only goods will be involved. There will be no sale, no service. A sale of a room air conditioner with incidental fitting may still be sale of goods. A sale of central air conditioner will be works contract. Then in K. Raija and then Justice Lodha judgment L&T, what we call new type of works contract service. In the traditional works contract service, Gann and Rankali is a contractor. It is called by, say, let us say Tata Steel is setting up a factory. It calls Gann and Rankali to come to his land in Jamshedpur and put up a factory building. So the land belongs to the customer. The supplier doesn't have ownership of land. He comes and constructs the building. He supplies sand, cement, steel, etc. and uses his labor. That will be a traditional works contract. Because land is the customer's land and the contractor constructs the customer's land. Post 2006, in K. Raja and other cases, a developer is constructing flats for sale to a prospective buyer. And between the developer and the customer, not only superstructure is going to be transferred, interest will be given. Underlying land also will be given either way of lease or sublease and undivided interest, etc. What I call as new works contract for developer. Please don't mix up between the civil engineer engaged with developer for constructing the building. The civil engineer contracted with the developer is similar to Gann and Rankali going to Tata's land in Jamshedpur and constructing a factory. That's a classical works contract, traditional works contract. The civil engineer visa with the developer, that is the traditional works contract. Between the developer and the customer, so-called modern, a new works contract, it all involves interest in land. That also is works contract. And definition 218 of a GST Act excludes works contract related to movable property. For example, tailor, when he stitches the coat for you, cloth is given by you. The tailor uses lining material, button, etc., etc. That's a works contract movables. The definition in 218 covers only works contract immovable. So when Gannon Drunkali goes to Tata's factory and constructs the building, factory building, that's a traditional works contract. A civil engineer is contracted by a developer. That also is traditional works contract. Between developer to customer is also works contract. Okay. But the important point is, in the developer to the customer, 5B focus on the superstructure only. And Schedule 3 refers to sale of buildings subject to 5B. They are also focused on the superstructure. And the abatement notification provides for exclusion of value of land. Therefore, in my humble opinion, when C and D refer to construction immovable property, it refers to superstructure only. Okay. And therefore, works contract service is supplied to construction immovable property refers to the cement and steel, etc. And therefore, land taken on lease is not hit by C or D. That's the logic. The focus is on construction immovable property. Why I gave this distinction? Because if you are in D, you get some benefit of the Supreme Court judgment. If you are in C, you don't get a benefit. Again, Mr. Kothari was telling me, sir, it may be so, works contract service. Clause D refers to goods or service or both. Works contract service is indeed a service. Because definite service is anything other than goods. In any case, works contract is something which is both. So therefore, I am covered by D. If it is not on his own account. It's a very important point. There, my view is, if you are concerned with an exemption notification, service tax or GST, etc., and if there are two exemption notifications available to you, you can choose any. Similarly, for classification the rate notification, if product falls in both more than one item, you can choose one which will reduce your burden. But 17.5 says no input tax credit in the following situations. Therefore, if you say, sir, I am not covered with the clutches of 17.5D, therefore I am eligible for credit. That may not be enough. You will be eligible for credit successfully under 17.5 only if you do not fulfill, you are not trapped by any of the clauses A to H or whatever it is. In other words, you are bending backwards and proving that clause D is not against you in this particular example because on own account, and 17.5D also refers to service or both. On works contract service can be covered by D. Similarly, is a correct answer, but an irrelevant and incomplete answer. So the revenue will say, sir, I am not denying under 17.5D. I am going to deny under 17.5C. So one thing which is irrelevant is you bending backwards and proving that you are not trapped by 17.5D. If it's a works contract service and they hit by 17.5C, and that's the end of the matter for you. Therefore, if the input procurement is a works contract service, then Khani Khatam. Now then Sunil now asking whether in future, whether we'll tell our suppliers to split the work contract into pure supply of goods and pure supply of services. Okay. And I can therefore escape the clutches of 17.5C. I wish you can do so easily and successfully. If it is the same supplier, you may have a challenge. There are two different suppliers. Even if they are holding a subsidiary, you are absolutely safe. The supply of goods comes from one, supply of service comes from another, then you can successfully avoid worst contract service, because supply from two different suppliers cannot be fused together to decide the classification. That is settled point. So A supplies goods, B supplies services. Then even if there is a cross-fall clause between the two, you will be outside worst contract service, and therefore outside 17(5)(c). If it's going to same supplier and they are going to split the supply into goods and services, okay, and if there is a cross-fall clause between the two, then it's a matter of debate and dispute. For reference, you all may see the judgment of Andhra Pradesh High Court by Justice Ramesh Ranganathan, delivered on 17 September 2015 in Larsen and Toubro, in the context section 6.2, even sales for central sales tax. There, the High Court took the view that once there's a cross-fall clause, the two together will be read as worst contract service. There is no question of goods involved in that. That's a judgment not in our favor, and that refers to a host of case law on that. Okay. So as far as worst contract service is concerned, splitting up, particularly the cross-fall clause, may not be easy. But you make it two different suppliers. Okay. And even if there's a cross-fall clause between the two, we are safe. There's no problem in that. Then the last part I wanted to discuss is on this functional test for a plant. Sunil, that's the one you wanted, no?
Yes, sir.
You are saying that it is unclear to you. Okay. It is not clear to anybody. Okay. You don't worry. You are not the only one who are having doubt. When I read the judgment of Supreme Court of Scientific Instruments, just Venkatarama's judgment, which is the leading judgment on plant, the better judgment on plant is written by Gujarat High Court in Helicon Engineering, okay, which has been approved by Supreme Court. That's much more detailed and elaborate. Okay. There, they use the test functional test, function utility test. All of you are chartered accountants. You will know the meaning of the word plant, particularly income tax, better than me. There are few tests, standard comments, nothing profound. This is not a reflection of any superior knowledge. Just look at Palkiola's book. He gives all this in one page. Plant generally is anything and everything which a businessman requires, a tradesman requires, except for items made for sale or bought for sale. That is, stock in trade is excluded. Anything which a businessman requires, except items made for sale or brought for sale. That is the first thing. Second, very premises from which he conducts his business may not be plant. Building itself is not plant. Your own office may not be a plant. You may not be able to work without that. Functional test is satisfied that it is an item required for your functioning. But is it a tool with which you can work? That's the word used in the judgments. That is, big or small is not relevant. For example, a cobbler will have a small knife, pen knife, for cutting leather, etc. That is not big. That is not the test. It need not have a moving part. What the doubt was, it can be a machinery only if there is an engine in it. Need not be. But when the cobbler applies that wax on the धागा ऊपर wax लगाता है, उसके बाद सिलाई करता है, the wax will not be a plant, but the knife will be a plant. Is it a tool with which you carry on your business? That's what the test is. And exclude the premises from which you carry on business. Of course, human being itself is not a plant. Therefore, for a lawyer, a book is a plant. I remember many years ago, one income tax officer asked for books purchased. So number of books and medicine I had purchased and given it to him. तो बोला घर का खर्चा है तो आप ऑफिस में क्लेम करते हो. मैंने बोला मेरे घर पे दूर दूर तो कोई डॉक्टर नहीं, कोई पढ़ाई नहीं करता. These books on medicine required for a central excise lawyer and customs lawyer. Why look at books? My library will have books on metallurgy also. My books will have on any number of commodities under the sun. That book is a tool with which a lawyer dealing with excise classification will deal with. ITR will be a tool with which you as a chartered accountant practices. That's the functional test. The very premises may not be. The specialized building, that's a slightly different situation. All this is different from the building itself is made available for the customer. On his own account will not be satisfied. So the functional test, of course, is on a case-to-case basis. Equal number of cases can fall on this side of the line. Okay. Where to draw the line is a very difficult point to decide. Okay. But they decide on a case-to-case basis. But to say there is nothing called a functionality test is incorrect. Functional test means only this. Is it a tool with which you carry on business? Exclusion should be very premise in which you conduct business and also stock in trade. Big or small, not having moving parts, not expensive, all that is irrelevant. Therefore, in my opinion, a shell of a building per se not made available to the customer may not be. This is apart from the point that in a mall, any case, you will be eligible for credit on lift, air conditioning plant, wiring, etc. Because whether you read it as plant or machinery, they will be certainly covered by that. Okay. Particularly when section refers to which are fixed to the earth by foundation structural support. So it is not necessary that in a multi-story building constructed by a developer, he will never get rid of anything. Even in his lot of items like electricals and lifts, etc., air conditioning plant, there are some doubts on some of these items, but they are not affected with the judgment. This is all I wanted to say, Sunil bhai.
Yes, sir. Thank you. I think it's.
You can give your comments. What are the points you agree, disagree?
No, sir,
And
I think.
also can give. Okay. Yeah.
Thank you, sir. I think you've thrown light on some of the important facets, and I think the research which you brought about explaining the Hindi version and especially the 3 states where the words are used in a different fashion. I think that was an eye-opener because I don't think that has been discussed elsewhere. And as you rightly said, even the Supreme Court has not looked at that parameter at all. So you nicely explained the key principles of the judgment and the key findings of the judgment. There are a few questions. Maybe we can take them up if it's okay with you, sir. We can take.
I can take any question. If I'm not able to answer, you will answer, or any one of you can answer. No.
Sure.
Bolo, sir.
So, sir, Ankita Shah has asked this question. She says that if our warehouse is considered a plant and we avail ITC on the construction expenses and then we sell the warehouse after a certain period of time, how would the ITC availed be treated? Will it be requiring a reversal or not?
That's a very contentious.
This is also the point which the ASG had brought about in his arguments that a property might be taken on rent and maybe if after 1 year he might just sell it off. That was also the concern of the ASG in the arguments. So I think that's what Ankita is also bringing about.
Let us slightly modify Ankita's example to make it more spicy.
Sir.
In the sense, if the initial agreement itself says, I will lease it to you for sole buyer, not hundreds of buyers. They say, we will lease it to you for 5 years and sell it to you after 5 years. Or I lease it to you for 5 days. That's possible, no? Sale and agreement to purchase can be there. Sale and lease and agree to sale is also possible. That also can be entered into. And you say 5 years, so there's 1 year, then 1 month, 1 day. Where do you draw the line, you will say? The answer is no easy answers. These problems are not because you don't have the skill in the law or I don't have the skill in the law. The problem is the law. Okay. The problem is the law. And this is very important to understand. Okay. This I've been telling this story for hundreds of times, but it's worth repeating also. It is familiar with all of you. In a customs, when you import a coil, you will pay custom duty, take the coil out of the customs, and custom fellow will not look beyond the port. But suppose you say rate of tax on coil used in making a car is 5%. Coil used in making dalda tin is 15%. Okay. The problem is Customs Act said, I will do everything done and dusted before it leaves the port. But you should link the rate of tax to what is going to happen thereafter. The Act is not geared to deal with this situation. That's a common problem in a number of tax laws. Your development rebate deduction is given subject to you being used for 8 years. Income Tax Act normally concerned with everything being done within that year. If the deduction is given subject to what is going to happen after the year, the machinery fails. Then you need to have 154. Then 154 will say on the day the allowance is given should be rectifiable. There's no mistake on that day. Then you have 155. Similarly, in GST, everything should link to at the time of supply. Nothing should be linked to anything else. Okay. And similarly for input tax credit, also it should be that. But once you put in a structure which doesn't feel within this, then there's a problem in that. The other difficulty is if you want to block the credit, okay, it should block by description, not linked to subsequent use. There must be distinction between 17.1, 17.2 and 17.5. It is if the credit availability is going to link to what is going to happen thereafter, that's a matter which will be dealt with 17.1 and 2, not by 17.5. But we have made a miss in that. And 17.5 C and D is also governed by Rule 42. Okay. So the question in Ankita, that's why I said change the example. So we have to say these are artificial situation, artificial answer alone is possible. The law decides applicability of credit on the day the supply is received or day you take the credit. What happens thereafter is not dealt with in it. And therefore, if you lease for 5 years, finish the credit and utilize it beyond this thing. In fact, you may word the lease deed that will be leased till the time credit is unutilized. The day credit stands utilized, I'll convert the lease into agreement to sell. Perfectly valid, no problem. Okay. Right.
So just to summarize, sir, your view, what I could understand is that 17.5D by itself will not apply at the starting point at the time of the credit. And at a later point of time when the sale happens, 17.5D will have no application. It has not to be looked at that point of time. Provisions of 17.1 and 2 may apply. But when you go to 17.1 and 2, those situations are not envisaged under the rules. And therefore, perhaps the full credit would be available. I think that is what I could gather.
17.1 and 2 focus obsessively on that month's return.
Exactly, sir.
Okay. And that can result in a windfall or a distortion of credit.
That's true. Sir, yes. The next question is from Prashant Deshpande.
Oh,
yes.
He's barred. He's barred from asking questions.
But it's an interesting question. I think partially you touched upon it, but I think I'll just put it across so that because since it's specifically come. So Prashantji asks, I understand that the Supreme Court has said about the escape routes. With due respect to the apex court, on his own account should have been read together with construction of immovable property. That means if the construction was not to be done by the taxable person but by someone else, then 17(5)(d) would not be applicable. Your views are requested on this aspect.
I declined to give my view. I carefully worded my observations. Supreme Court has concluded, because I am told sometimes some of these sessions are heard by revenue people also. Oh, okay.
Okay,
We
sir.
don't want BCS, certainly it will be recorded and this thing.
Yes,
Okay.
sir. Yes, sir. It's recorded.
So the superior wisdom of the Supreme Court prevails over Sunil's view and my view. Okay.
Sir, I think we rest it at that. We go to the next question by Mr. Vishal Kumar. And I think it's again, somewhere you addressed it, but just to reiterate, the question is whether ITC on construction of a building
Yes.
for renting and leasing of premises can be claimed.
I told Chief Justice Judge Chandrachud once, sir, a tax lawyer, successful tax lawyer, need to know only exemption sections. Then he can survive successfully. He need not learn the taxing sections. Similarly, you need to know the sections where credit is available. So, aapka kaam chal jayega.
Sir.
Then Justice Chandrachud said, how easy Sridharan, he said.
Yes, sir. Sir, only one facet which is coming out is that the observations of the court and even the language, the way we interpret it, is to say that if the construction is done, which is intended for lease.
Yes.
And the timing of the construction with most of the examples predates the actual execution of the lease. So, on how would a taxpayer actually demonstrate an intention to lease? Because intention, sir, many times is always a slippery word.
The Supreme Court has said in Dalmia Dadir and other cases, for use means intended for use, not actual use.
Yes,
Okay.
sir.
But those judgments were dealing with the situation where the act in question, the section in question, used the word for use or intended for use. Here, these words do not figure in 17(5)(c) and D.
Yes.
Okay. And therefore, Supreme Court says intended for. But then, sir, as Lord Mansfield said in 15th century or so, even a devil doesn't know what is in a man's mind, but a judge is supposed to know. In criminal law, who intends to? Okay. The circumstances never lie, they say. Okay. Witnesses may lie, circumstances never lie. So you don't use the word intent so much in our tax laws, but in criminal law, everything, whosoever intends to do this, how do you gather the intention? Okay. From the act. So therefore, in some sense, from a project report, this, etc., you can have an idea. It's not an easy answer. Okay, that's the only way. Okay.
Sure, sir.
Intended for use, not used in the act. Therefore, Dalmia Dadir is not relevant. We can successfully confuse court with that. And intended can be, that's the fact. There's no clear answer to all this. Okay. Because the structure of the judgment is itself little. Okay, next.
So next question is from Haresh Kagrana. The question is that a company is buying an under construction office. So we are talking about the new works contracts by the developer. And it is in a regular business of letting out the office or commercial premises. Whether it would be hit by section 17(5)(c) or D, an input credit can be denied. Or is the builder supplying works construction service and not works contract service? So section 17(5)(c) or D is not applicable and eligible for credit.
I'm not able to follow.
So it's a case where, let's say, there is a person who books units in a commercial property being developed. So naturally, the builder developer is going to charge him GST.
Okay.
Which is that the new works contract which you referred to, L&T wala works contract. And he intends to actually lease it out.
Who?
The person who is booking that unit in that developer's property is intending to further lease it out.
It's a purchase of constructed flat at 12%, which he's going to lease out further.
So construction not on his own account, as per the judgment of the Supreme Court.
Yeah, so construction is not on his own account. So,
but whether it is works contract service or goods or service,
that is the question which Haresh Bhai is asking.
Okay.
So for construction, I perceive general construction. So section 17(5)(c) and D says goods or services / works contract services supplied for construction of an immovable property. Here what he is receiving is an already constructed unit. So it is not for construction. So anyway it will not be hit by the bar of section 17(5)(c) and D.
Yes. So what you are trying to say, Nivedita, is basically that this is a service of construction received, not service for construction.
Yes, correct. You put it better. Hmm.
No, I
Yes,
think that's
next.
a wonderful argument, I think.
Hmm.
We go to the next question by Ramji again, which is answered partially. The question is, will a lift in an office be a plant which is used for transporting clients to the office located on the second floor? I think, sir, you have perhaps
We need not even
that it is
refer
an-
to why need to bother about lifting the persons. You say it's plant and machinery, no? Hmm.
Yes.
Hmm. The lift doesn't need a lift in that sense.
Yes, sir. So I think there's a question from Vaibhav. A developer avails works contract supply and outward supply is construction services. So from a developer's perspective, whether a commercial project will be hit by restriction under 17(5)(c).
Will be hit, no? Hmm. Will be hit. Hmm.
But
Because it is but I can't imagine outward supply being not a works contract service.
yes, sir. That was the key
Hmm.
point which I was also going to ask.
But if you assume
Hmm.
that it is indeed a construction service. Sure.
So the next question is, what would be the effect if an amendment is made and or is replaced with and?
It will be prospective. Somebody can say is to remove a defect, etc. Therefore, clarification retrospective. हो सकता है, कुछ भी हो सकता है. Okay. I am told for whatever reason, if of course, I have no basis for this, and it is important to realize this part. To go for an amendment retrospectively, the government may, maybe the revenue secretary, finance minister said no, amendment prospective. Why? Because opposition will say you don't know how to do your job, we made a mistake, you are making retrospective. For political reasons. So they say let bygones be bygones, even if there is a mistake, government will bear the loss, will make prospective amendments only. I was told in 2018, some officer from Patna prepared a list of about 80 mistakes in GST Act. He took it up to the finance minister. He says, already I'm in trouble saying GST is poorly drafted, etc. There's no way I will touch this. Get lost here. I was trying to desperately try and get the copies of that 80 mistakes, but I was not able to locate. But that's how works. Government works. Okay. So if an amendment comes, government will certainly make it only prospective.
Okay.
They will not make it retrospective. But Solicitor General can argue, sir, this is obvious mistake, then retrospective. Okay. That I do not.
Interpretation of that amendment retrospectivity will again be another open position for litigation.
No problem.
Next question is, if a taxpayer is engaged in clearing forwarding activities and has built a warehouse, whether he will be eligible for ITC?
He's not letting it out, no?
No. If he's using it for self-purpose, he will do a storage warehousing and charge warehousing charges or things like that.
And assuming that is not on account, it is not hit by 17(5)(c). Okay.
He would be hit. The next question is about a mall itself. He says a firm has constructed a mall and given for rent. Can the ITC on works contract, which is lift and electrical fittings, be claimed? Yeah, because that anyways would also fit within the definition of plant and machinery.
Provided it is not works contract service. Plant and machinery will get any case. A lift will get at C also.
Yes. And only other than plant and machinery, we'll have to make sure that it is goods or services separately.
अभी नहीं हो सकता, हो गया पीछे, माल तो बन गया, rent out भी हो गया.
Yes, yes. I think the next one also has been addressed. It's a repetitive question, so I'll just do away with it. Sir, this is an interesting question from Rajesh Bed. And again, you touched upon that issue of leased, long-term lease. Sir, the question is, if I am doing a construction on a leased land, whether it will be
decided as an own account, not based on land. Okay.
Land is not my own.
उससे फर्क नहीं पड़ता. Land is owned, not owned, उससे फर्क नहीं पड़ता.
Yes, sir. So the question which comes is, sir, especially when you look at MIDC, MIDC enters into, sir, as you are aware, two structures, two agreements. One is an agreement to lease.
Yes.
It allots you a plot of land, allows you to enter into the premises with a limited.
MIDC issued a circular world over saying that we are of the use Sridharan as advisor, therefore you are charging Uber.
The terms of the agreement are such that the intended licensee.
What's the content? What's the query? What's the query, Sunil bhai?
Sir, the query is that the structure which is constructed by the licensee under the legal agreement, the ownership of the structure also belongs to MIDC. And the lease agreement is entered into for not only the lease of the land, but even the structure.
But this is not connected with what we are discussing, no?
Sir, the question therefore is that if as a licensee, I am incurring a cost of construction, I might be incurring the cost, but I am not doing it on my own account. I am actually doing it on account of MIDC because the ownership of the structure belongs to MIDC.
But you are not getting anything from MIDC, no?
No, I am getting just the lease right. That's all.
So you pay and still it is for MIDC.
Yes. So that was, I think, the question which is asked, whether it can be said to be for own account in that case, or can I wriggle out from that thing?
No.
It would be ambitious.
It's for a different clause. That will take half an hour to explain that. You can keep another Wednesday whenever you want.
Sure, sir.
Only on MIDC leases, etc.
Okay. The next question is of a builder developer who is selling under construction commercial properties. And naturally, till the time he is selling it under construction, he claims the credit. At the time of OC, Rule 42 requires him to reverse the credit to the extent of unsold inventory. And if that unsold inventory is later on given on rental basis, whether he can reclaim that reversal. Can he say that now for this part, I want to go under 17(5)(d)?
No. Just now we discussed available credit will be decided at the time of taking the credit.
At the time of the
some may be a windfall, some there will be distortion.
That's true.
It cannot be in logical lines. How many more questions, Sunil bhai?
Some of them are repetitive. So the repetitive questions I'm just skipping and I'm just seeing if there's something. We'll just take one or two questions more. I think Kalpesh Bhatt is asking if company A is related to company B and they are independent contracts for goods or services, whether company A can avail the GST credit. I think you answered, sir, that even if it's a holding subsidiary, it would still.
I gave this example because there is a judgment in UK. Broadcasting was taxable, books were exempt. And when that operator supplied both, he ended up paying on book value also. Then these programs, those days cable TV people used to send a monthly program. So then he supplied the book through a subsidiary and the channels were continued with the holding company. The court held he cannot club these two and book value will be exempt from GST. Holding and subsidiary created only for this purpose. See, Kerala High Court also, in Abbott also supply with two separate cannot be fused together.
Sir, I'll take the last question, and the question is actually relevant from a practical perspective that there are entities which have conservatively reversed the ITC already or not claimed it in the first place. The question is, can it be now claimed considering that the Safari retreat somewhere is unlocking based on the interpretation of this own account or any
subject to your 16.4, you can do that.
Sure, sir. So I think that was
only subject to 16.4.
I think I'll hand it over back to. It was a wonderful.
And it will be simple for you. You must have known all this better.
I'll hand it back to the President Anand to take it ahead from here.
Your closing remarks should not be as impressive as opening remarks, sir.
No, sir.
Sir, that's why
hence I'm requesting Mandar to do the needful.
So, sir, before coming to the pleasant task, which obviously all of us are waiting for your vote of thanks, I have a couple of announcements for our audience.
Please.
So there are 3 study circles meeting that we have scheduled in the next, in the next week or so. So the first meeting is on the inheritance of the succession planning, which will be held on 28th of October 2024. The 2 meetings will be held on 24th of October, one of which is on the indirect tax study cycle meeting, which is on GSTR 99C, and another will be on the adjudication orders and recent amendments under the Companies Act. The details are available on the website. So those who are interested can definitely visit our website and see where those meetings are going to be held.
we have a very interesting AI related sessions workshop, AI and Technology ki Pathshala, that is going to be held on 7th of November and 8th of November. So those who are interested in technology can certainly attend to these workshops. We have also announced our flagship event of 58th Residential Refresher Course, which we refer to as a General RRC, which deals with various subject matters on 26th of February to 1st of March 2025. Announcement is already out, and this RRC will be held at Lucknow. So those who are interested to get a mixed flavor and also to visit the Ayodhya temple, they are most welcome to attend to this particular RRC. With this, I now come to a very pleasant task. Sridharan sir, whenever I hear you, it gives me a nostalgic feeling as if I'm going back some 10 years back and I'm sitting in my law class and I'm listening to my teachers. And all of us today, in the way you have explained, got the same feeling. We were listening to you as if we are the students and you are teaching us the subject matter. I thank you a lot for this, crisp, but yet a very detailed, very deep insights of the judgment that you have shared with us. You have touched upon a very important aspects, words which are used in the judgment in the law on your own account, the functional test, and or whether that is right, wrong. So all these things what we have highlighted, and especially the part that your colleague Nivedita has brought out about the
I express a vote of thanks to Nivedita.
So
She has
all of
coached
that.
me.
It was very enlightening session, and I hope to continue such sessions with you in a time to come. Thank you a lot, sir. Thank you.
Entire thanks to Nivedita. She has done everything. I only was mouthpiece for her. Credit to her.
Both of you, sir. Both of you. Thank you very much.
Thank you.
Thank you.
Thank you, Sridharan sir. Thanks, Nivedita. Thank you, Sunil Bhai, as well. Thank you very much. Thank you.